Bonjour à tous. Avant de commencer, je voudrais vous
Hello
rappeler
to
que
everyone. Before
nous
we start,
disposons d'une interprétation
I wanted to
anglais-français.
remind you that we have
Il vous
French
suffit de cliquer
interpretation
sur
today. You
l'option
just need to
d'interprétation
click
sur
on the
Zoom.
option
Hello everyone. Before
on
we
Zoom.
begin, I would like to remind you all that we have English French interpretation. You only need to click the interpretation option on Zoom. Soyez les bienvenus à notre troisième webinaire de cette
Welcome to
série
this
dans le
third
cadre du
webinar
lancement
of
de
this
la
series
version en langue française
in
de
the
la base
context
de
of the
données
launch of
mondiale de
the French version
jurisprudence.
of the
Je suis
global
Anderson
database
Javier
of
de Rossi de
jurisprudence
Leon
case law.
et au nom
My
de
name
Columbia
is
Global Freedom of
Anderson
Expression,
Javier
je
de
suis
Rossi de
très
Leon,
heureux de vous
and
accueillir
I'm
aujourd'hui
very
et d'ouvrir
pleased to
ce
welcome you
webinaire sur le
today
discours de haine
and to
que nous
open this webinar
organisons en
on the hate
collaboration
speech.
avec
We
Article
are
19
here in
Sénégal
collaboration
et avec
with
le soutien
Senegal
des
and
experts du
the
panel.
support of
Columbia
experts.
Global Freedom of Expression est une
Columbia
initiative de l'Université de
Global Freedom of
Columbia
Expression is an
créée en
initiative that it
2014
was
par
created
Lindsay
in
Bollinger,
2014
alors président de l'université,
by the
afin de
president of the
promouvoir les
university
normes
in order to
internationales les
promote
plus
international
élevées en matière de
standards
protection judiciaire de la liberté
in
d'expression
with
et de la
respect with
liberté de la presse à
freedom of
l'échelle mondiale.
expression and freedom of
Notre projet
press
phare
at
est
the
la
global
base de
level.
données mondiale sur la jurisprudence en
Our
matière de
project
liberté d'expression qui héberge
works
plus de
on freedom of
1200
expression
analyses de cas en anglais de décisions judiciaires de 130 pays, y
sorry, the
compris
interpreter
toute la
apologizes, the audio
jurisprudence relative à
is
la
not
liberté
coming through
d'expression de la
properly.
Cour interaméricaine des droits de l'homme, de la Cour
So
africaine des droits de l'homme et des peuples et de la
we
Grande Chambre
also
de la Cour européenne
have the
des droits de
support
l'homme.
of the Grand Chamber of the
La version
European
en
Court.
français compte
The French
déjà plus
version
de 100
is
cas,
already
est
counting
entièrement
over 100
consultable et
cases and
contient
is
des informations selon l'âge
searchable and has
d'éventail des questions
information
relatives à la
on
liberté
many
d'expression
questions
dans le monde entier.
linked
En
to
plus,
the
de
freedom of
nouveaux
expression
cas
in the
seront
world.
ajoutés chaque mois.
New
La
cases will
base de
be added
données
each month.
contient également des
The
traductions de
database
6
also
documents de recueil
contains
spécial sur des
translation
sujets
of
tels
the
que les
cases,
coupures de l'accès à l'Internet en droit international, les droits de
access to
haine,
internet,
les droits à l'oubli,
the right to be
ainsi que la
forgotten,
jurisprudence de cours
and
régionales
also
telles que la Cour
case law
interaméricaine, la Cour
on
européenne et la Cour africaine des
of
droits de
the
l'homme et des peuples.
American
Ces
International Court.
documents du recueil spécial systématisent
These
la jurisprudence de la base de données
documents
mondiale sur la liberté d'expression,
are
offrant une
available
perspective
and
globale de
give a
certaines des
global
décisions juridiques
perspective
les plus
on
importantes
some case law
adoptées par les
decisions
tribunaux
that have
nationaux et
been made and
internationaux
adopted
sur des sujets pertinents
on
concernant la
relevant
liberté d'expression.
subjects relating
Il est
to freedom of
important de
expression.
noter que
It
la base de
is
données en
important
français et cette série de
to note
webinaires
that this
sont rendus
database
possibles
and
grâce
webinars
au
are
soutien du programme
made possible thanks to the
multi-donateur
support of
de
the
l'UNESCO
Multi-Donor
sur
Programme
la liberté
by
d'expression
UNESCO
et la sécurité
on
des
freedom
journalistes
of expression
et
and
du
safety
Cyrilla
of journalists,
Collaborative avec le financement
and
du Center
also
for
thanks to the
Intellectual
funding
Property and
of Center
Information
for
Technology Law
Intellectual
de l'Université de
Property
Strathmore,
of
Nairobi, Kenya.
Strathmore
Je tiens donc à les
University
remercier
in Kenya.
chaleureusement pour le soutien.
I wanted to thank
Dans
them
le même
warmly for
ordre
their support.
d'idée, j'aimerais profiter de
I
l'occasion pour vous
also
inviter au
wanted
dernier webinaire de cette série, le
to
2 avril, sur
remind
la
you of the
jurisprudence du
last
système
webinar
africain
on
des
the
droits de
2nd
l'homme
of
et des
April
peuples.
on the
Nous vous
protection
laisserons
and
le lien pour
limitation of freedom of
l'inscription dans le
expression
chat.
in the African system.
Nous pouvons
You
ainsi
can see it
commencer.
in the chat.
Ce
We
webinaire
can now
durera
start
1
this
heure.
webinar,
Il est ouvert au public
which will
et
last for
est
1
diffusé sur
hour.
notre chaîne
It is
YouTube.
open to
Vous pouvez
the
poser vos
general
questions
public
tout au long du
and will be
webinaire
published
sur
on
le
our
chat de Zoom en
YouTube
public.
channel. You can ask questions
Permettez-moi de
anytime.
réitérer ma
Now,
chaleureuse
I
bienvenue et de passer la
want
parole
to
à François Jouni,
welcome
candidat
François
au
Jouni
doctorat à
and give him the
l'Université de
floor,
Nantes, qui nous
candidate
fera
and
l'honneur de
doctoral
modérer le panel.
student
Merci.
who will now take the floor. Thank you. Thank you, Anderson, and thank you to the whole team for welcoming me in this webinar. We have the honor and the pleasure to have with us today Ms. Alkeviadou, Dr. Alkeviadou, who is Senior Research Fellow at Justicia and wrote the article of the enduring question of thresholds and will now present this paper and explain where the threshold of tolerance is in hate speech in different case law, and will explain to us the limitations of hate speech. Then we will have Bernard Chevalier, who is advisor to the First Civil Chamber, and will talk about the two infractions of the 1981 law And all this will be supported by the European Court. Now I give the floor to Dr. Natalie Alkiviadou.
Hi, everyone. Thank you very much for the invitation. I'm really happy to be speaking today along with Francois and Bernard. For those of you, so I have 20 minutes, so I'm now timing myself. For those of you who have read the paper, it's rather like a very long report of quite a bit of case law from the European Court of Human Rights. So I think the tricky part for me today was to be able to just choose a few cases for purposes of discussion. I don't want it just be me reading out the report. That would be very boring, and you can do that yourself. So I've chosen a few cases to discuss, and essentially to make a couple of points that I think are very, very important when it comes to the analysis of European Court of Human Rights case law on hate speech. So let's start with a very basic case of freedom of expression jurisprudence before the court, that being Handicide versus the United Kingdom. An old case, but a case that stays with us, and a case that paradoxically is more often than not, if I had a very good memory, I would probably say in all cases involving hate speech, or at least all cases involving hate speech, Handicide versus the United Kingdom is actually quoted by the court itself through its legal analysis. And in this case, as we all know, the European Court of Human Rights essentially said that the freedom of expression, as guaranteed by Article 10 of the Convention, does not only extend to expressions which are favorably received, but also those which may offend, shock, or disturb. It may be definitional kind of mismatch or misunderstanding with the people who sit, the judges who sit at the court, but in my personal academic point of view, I don't see how this very, very significant landmark case has subsequently been upheld by the court itself. So the general framework is that the very robust protection given to freedom of expression, even when we included cases which offend, shock, and disturb. What we subsequently see in hate speech cases, and I'll go back to what we may think hate speech means. I'm not very sure, to be honest, and I don't think the court is either. But what we do see is a kind of dilution of this freedom of expression. And my aim today is to show you this dilution. Now, as a first kind of step, I think it's very, very important. I don't want to waste time on definitions, but I do want to make a point. Hate speech has been kind of thrown around by the European Court of Human Rights in a plethora of cases, even in cases involving the banning of scholarly books, in cases involving posters, in cases involving comments on the internet. Hate speech has definitely been used quite a bit. It was only until the case against Iceland, the case of Lillian Dahl versus Iceland, a few years back, which involved homophobic and transphobic speech, where as you were reading the judgment, you felt, okay, maybe now the court is actually going to tell us what it thinks of hate speech. I hope I'm speaking in a sufficient tempo for the translators. If not, please just send me a message. Right, so Yeah, so in Liliendahl, the court started to kind of investigate what hate speech may be. But instead of actually offering some kind of content or context of what it might imagine it to be, it simply relied on previous cases in order to establish a hierarchy. So it said that the gravest form of hate speech are excluded from any convention protection because of the use of the non-destruction clause of Article 17. But the court offered no definition of what the gravest forms of hate speech may be. So that was the top of the hierarchy. And then on the second level of the hierarchy, the court referred to less grave forms of hate speech, which don't fall outside Article 10, but which the court has considered permissible for the contracting states to restrict. So it's really significant to stress the differentiation between when Article 17 and Article 10 arise, because when Article 17 is put in force, essentially we are absent of any proper legal analysis under Article 10. So like the multifold test that comes with Article 10 as developed over time is absent. And in my personal opinion, that is quite chilling for freedom of expression. And, you know, in our minds, people working on hate speech predominantly, we link article, il s'agit de l'article, okay, I don't think that's me. When we do think of Article 17, we do think of denial of the Holocaust, negationism when it comes to the Holocaust. And that has been not always, but quite systematically used, Article 17, that is, when it comes to Holocaust denial. And in my discussion with Francois just before the, in preparation for this seminar, he said to me, "Yeah, Bob, we need to discuss Lenis versus Greece." And it had completely kind of went over my head that I'll come back to that in a minute, but how that case also relied on Article 17. It's a very, very recent case, and that involves homophobic speech. So the pattern of the court when it comes to hate speech is to, and you'll see this throughout the report, is to, and elsewhere, not just in my report, is to kind of keep Article 17 for cases involving Holocaust denial and negationism and some hate speech, which is anti-Semitic. But we have seen some examples whereby it has been used for other forms of hate speech, very rarely though. And one of the cases that is that of Norwood versus the UK. This is a beginning of the 2000s, and this a British man prepared this very large poster which he hung up at his window, which said, "Protect the British people, Islam out of Britain," and then there was the crescent symbol and with an X marked across it. And he had tried through the national courts. He ended up in the European Court of Human Rights, saying that his freedom of expression had been violated, but the European Court of Human Rights said, no, this is an Article 17 case because of the huge detrimental impact on the targets of that speech. So just to close up on the use of Article 17, yes, we do see it most often used for anti-Semitism, genocide denial, Holocaust denial, and I'll make the distinction in a minute. But we do have a couple of cases that differentiate. And this is where I want to draw a parallel with a case against Switzerland, whereby there was a discussion. So the applicant brought a case before Strasbourg after he had publicly described the Armenian genocide as an international lie. He got into some predicaments in Switzerland, and he went to the European Court of Human Rights and he said, you know what, this is my freedom of expression. And there, the court was quite surprisingly thorough when examining the case, something that unfortunately for hate, sorry, I shook my screen. Unfortunately for hate speech cases, it's not something that we see very often. Of course, we mustn't generalize, because we must always remember the role of the European Court of Human Rights, how many contracting state parties, the way it tries to manage, you know, quite a few different legal cultures, and of course, the very, very important issue of the margin of appreciation. So I'm not justifying, by the way, any restrictions on freedom of expression. I don't like those, but we must always place things within context of the particular court, right? So in a judicial manner, I can't compare the functioning of the European Court of Human Rights, for example, with a national court when it comes to decision-making on another country. They're very, very apt in realizing that their cultural sensitivity is not as strong as, for example, that of the national authorities. But in this case, they were really extensively discussing just how it's really important that matters of public interest are extrapolated upon in public, and it highlighted that the determination should be made by historical research, and that there must be debate, and that our understanding of history is debatable. You know, it gave quite a bit of an in-depth, for the European Court of Human Rights, context on what history actually is, and how history and historical memory and historical kind of definition actually varies. But this approach was never followed in regard to the Holocaust. It was kind of a given. Someone may come and say, you need to look at the history of the Council of Europe and, you know, how it was established and what the reason may be. But at the same time, when it comes to legal analysis, I do think that, you know, this Swiss case, Perinček, I would pronounce it as, it does show the differentiation that when the court actually does want to give a justification, it may actually do so. And in this case, not only was Article 17 not used against the applicant, but actually the court found that there was no violation of Article 10, and that, you know, it was just kind of, it didn't fall. It did fall within the ambit of Article 10. So I hope I've made that kind of differentiation reasonable. We can discuss it later as well. So closing on Article 17, I'd like just to go quickly for the last part on how we've kind of reached today's situation, which I would say today's situation has led to two very important cases. That of Sanchez versus France, quite a dismal ruling, in my opinion, a worrying ruling, and a ruling that kind of reflects what's coming in the future within the age of, you know, social media platforms and expression moving onto those mediums, or having already moved, and also the case of Lenis. Now, if someone were to ask me, where would you go back to show this development? Of course, there are older cases, but I would start from the case of Ferrer versus Belgium. This is a 2009 case, and this involved the leader of a nationalist Belgian party that was giving out flyers. There was different kind of publications with statements such as "Stop the Islamization of Belgium," "Save our people from the risk imposed by Islam the Conqueror," etc., etc. the applicant got into a bit of a predicament in Belgium, ended up at the Court of the European Court of Human Rights, and the court there said there was no violation of Article 10, but it rejected, and this is very important, the Belgian government's request for the enforcement of Article 17, the non-destruction clause. So if one has Ferrer versus Belgium, you know, protect us from the Islam, the conqueror on the one hand, and then you remember Norwood, which I mentioned a while ago, which was just a few years difference between Norwood and Ferrer. There we had an application of Article 17, and unfortunately in the judgment there isn't really any explanation why Article 17 was used for Norwood but not Ferrer. I mean, I wished it wasn't used for any, but it would be quite interesting to see the thinking behind it. And then in the in one of the dissenting opinions, including it's Judge Sayo, joined by another two judges. I'll try and pronounce their names. It's Zagrebelski and Sotsoria. It's quite a humorous but very, very strong dissenting opinion, in that the judges basically said the court is just treating people like nitwits, you know, idiots, people who cannot kind of understand or read or have any critical thinking for themselves, because the whole thinking of the court was that we have to protect, and this is quote by quote, you know, kind of avoiding the arousal of bad feelings towards, in this case, Muslim people, particularly among the less informed members of the public, because then feelings of distrust, rejection, or hatred towards foreigners may arise. So that's where we started going beyond simply looking at hate speech, not simply, but something that may promote violence or may promote hatred, or which is a disputable term anyway, by essentially having the court saying that inciting hatred doesn't actually have to advocate for violence. It doesn't have to actually call for any criminal acts. It can actually simply be insulting and prejudicial. So once we got this very low threshold, so we have this idea of insult, of prejudice, of no reason for there to have the speech inciting violence, for example, we can definitely see the pattern unfolding. And it unfolded slowly but surely, because Ferrer and the paradigm established by Ferrer with the very, very low threshold, which is also very contrary to what was decided in Handyside versus the UK, which was a more generic freedom of expression case, which essentially said that speech can extend to that which shocks, offends, and disturbs. We had this pattern which was slowly but surely growing, and we later went to the case of Veland versus Sweden. This concerned a group of young people who had disseminated highly homophobic leaflets in a school. 2 minutes left. Thank you. In a school locker, and there were different statements like that the gay community was responsible for pedophilia, for AIDS, that they were deviant, different things like that. And there the court again followed the Ferrer kind of paradigm and said, you know what, you don't need to call for an act of violence. You don't need to call for some, you know, a criminal action. Hate speech is hate speech, even if it's insulting or prejudicial. And that's been followed throughout. And just to close, this is essentially what happened in Sanchez. The low threshold that we've been seeing over the years has finally metastasized, not on the speaker themselves, but rather, so in this case, it was a political figure, but that he making a post, and under that post, the problem was under that post, there were several comments. I don't have time to go into details, but he was held responsible by the European Court of Human Rights of not dealing with those comments in time. And for anyone interested in when to deal with comments online and what the European Court of Human Rights says, you can have a look at Delphi versus Estonia, which I haven't had a chance to look at. And then we close with the latest case, Lenis versus Greece, where some statements were made, again, highly homophobic. We should blacken them, they are a disgrace, we should spit on them, etc., etc. And this case, although we've seen this kind of context also in Liliendahl versus Iceland, this case actually saw the use of Article 17. So my time is up. It's been very difficult for me to give an overview, but I hope to have given something to discuss. Thank you very much.
Thank you, Dr. Akiviadu, for this overview. It's true that this paper is very rich because it covers many, many aspects, and I invite our participants to read it themselves to have their own idea. In the French version, I think that the first the first aspect wasn't mentioned. So handicide in 1976, that sets the basis. I think it is interesting to mention that. And also the decision Perinček against Switzerland, I think it requires attention. And there is a difference between the one in 2013 and 2015 that are important regarding the controversy. Thank you for your intervention. I will just make two observations. The first one is that international institutions, among which the European Court, react to international institutions, and there is a dialogue among judges regarding the appreciation margin, and also the balancing between freedom of speech, freedom of expression, and the right of people. So I don't think we can mention hate speech without taking an interest into thinking, the way of thinking of each country, of each state. And most hate speech cases that were mentioned by Dr. Akiviadu are dealt with by the court. And the civil voice is also important. We think about the case law of the United Nations in order to mention the dialogue between judges and the alternative ways of the penal court. I wanted to invite Bernard Chevalier for his intervention. Thank you very much. I hope that everyone hears me well. Can everyone hear me? Yes. Everyone hears me correctly. Good. Hello, everyone. Thank you for inviting me. And I want to say that I'm very honored and pleased to speak today and share with you these reflections on this very important, interesting topic. I would like to offer a brief exchange of ideas and the perception by a national judge of the confrontation, the comparison between a freedom of expression and prohibition of a number of abuses, a violation of protected rights. Nathalie Alkiviadu reminded us that freedom of expression is a fundamental right granted, especially for a European judge, a French judge, by the Article 10 of the Convention on Fundamental Rights and Human Rights. But the Article 10 not only affirms in the first paragraph the value of this fundamental right, fundamental freedom, it also expresses at the second paragraph that this freedom can be object to restrictions with the condition that it is foreseen by the law and with a legitimate objective aim. So among these legitimate aims, on the second paragraph of Article 10, we have the protection of reputation and rights of others. And I wanted to make two examples in which this confrontation comparison is interesting. So the first one is defamation. It is foreseen in the law of 1981, Article 29 on freedom of speech, define any allegation or public incrimination of a fact that is a prejudice to the honor of a person. So the person who had this hate speech is not sanctioned if this person can demonstrate the truth of these allegations. Moreover, the case law added for the person who made this speech the possibility to escape this sanction if they demonstrate the existence of elements that, when they had this hate speech, can demonstrate that they were true. So the demand level of these elements of proof by the author vary if the person is a journalist, a professional, or only a private person who does not have the same deontology obligations of a journalist. Sorry. So in the French case law, to recognize the good end to the author, we need to take into account 4 criteria: the legitimacy of the end, the absence of animosity, the prudence in the expression, and the absence of investigation or factual basis. So the national judge has two sides of his judgment. The speech is the speech detrimental to the honor of the person? Second, the author of the speech, was that person able to demonstrate the truth, and can we give him the excuse of good end? So in Strasbourg, the case law and this appreciation of the two conditions guides the national judge, and at the same time, the control that is done by the French Court of Cassation is very important. In this way, the European Human Rights Court says that if the litigation speech is within a general interest debate, the other two conditions, the absence of personal animosity and the measure within the expression, need to be appreciated in a less strict way. And the criminal chamber spoke about this principle in different decisions that were made, namely the one in 2020. So we have indications on the way with which we need to envisage the existence of a factual basis that is sufficient. When the imputation is linked to the expression of an opinion or a value judgment, the EDHR can justify. On the contrary, the same convention said that the basis needs to be more solid when the facts are precise, and when these facts afterwards can be recognized as a penal incrimination. So the facts need to be solid. So now we have the different steps of the rationale by the European Court. In a recent decision in January 2024, Allais against France, Miss Allais had been condemned to a 700 euros fine and needed to also pay 2,000 euros fine for public defamation after sending emails to people from the association she was working for and also external people. In these emails, she was she was denouncing harassment, sexual harassment by the president of this association. And her request was rejected. That's why she went before the Court of Strasbourg on the basis of the Article 10 of the Convention. The European Court has this following rationale. Starts to see if there is interference in the freedom of expression, and the European Court considers that the decision of applying a fine is indeed an interference. And there is a necessity to see if it is compliant to Article 10. Then this interference is seen as foreseen by the law, according to Article 29, law of 1981. So this article has a legitimate aim, which is the protection of rights of others, president and vice president of the association. And in the end, the European Court of Human Rights examines the proportionality of the sanctions according to the context and the nature of the speech, the situation, and the intention of the person, the number and the quality of the beneficiaries of the email, the gravity of her speech and of her words, and the gravity of the sanctions. In this case, Allais against France, the European Court of Human Rights estimated and judged that this was excessive, the damage was excessive, and the French jurisdiction, by refusing to better adapt to the circumstances of good end, had a disproportionate impact on freedom of expression. So now regarding racial hatred, incitement to racial hatred, it is sanctioned by the French law, by Article 24 and 33 of this 1981 law. When the French judge, is presented a complaint on these provisions, he needs to examine the constitutive elements of this infraction and see if these words, by their meaning and their scope, incite for hatred or violence, or if they have a discriminatory character towards a person or a group of two people because of their origin, their belonging or non-belonging to an ethnic group, nation group, or religion. These decisions also led to decisions by the European Court of Human Rights, who estimated, not surprisingly, that the sanctions pronounced on the basis of these articles of 1981 law had a legitimate aim, which is the protection of other people's rights. And regarding the people who were condemned, the law examines the context in which these words were pronounced, if there is a public interest involved. Words that were in this case the necessity of protection, or if these words defend violence, hatred, xenophobia, or other forms of intolerance that, according to European Court of Human Rights, are not protected or in a very limited way. Then the court also examines the contested sanction, and if it is proportionate to the aim, and if it can be justified according to the European Court. According to the gravity, these words that incite to hatred can also fall under the Article 17 of the Convention that prohibits the abuse of rights, and that foresees that no provision of the Convention, such as Article 10, can be invoked to go against the aims of the Convention. And Article 17 has as a consequence that when the European Court of Human Rights considers that these words are of enough gravity, the effect is that the person, the author of the speech, cannot use the Convention and cannot, before the European Court of Human Rights, have the freedom of expression guaranteed. The European Court of Human Rights can then decide that the request is inadmissible, unfounded. But there is an exceptional case, and in extreme cases, it is clear that these words were aimed at changing the final end, and the aim was contrary to the value of the Convention. And to characterize these elements, the European Court takes into account not only the words and the context in which they were obtained, but also what the real intention of the author was. I think I've finished the time that was given to me, but if you wish, we can now mention the questions that you might want to ask. So I gave the floor to anyone who has questions. Thank you, Mr. Chevalier, for this precise presentation. I can see that we have one question in the chat, only one question, as far as I can see. Before we go to that question, I had a question. Dr. Alkiviadou and yourself have referred to Article 17, and I was wondering, and I'm asking you this question, Mr. Chevalier, the national judge, have them considered, did they consider using this article within their jurisdiction? So Article 17 is not directly applicable in internal rights. Article 17 has the only function to deprive someone of their right before the European Court of Human Rights to use to prevail from Article 10. So this Article 17 cannot have an effect on French law, as I tried to explain. The national judge, French judge, when it is seized for a complaint against someone who had discriminatory or hate speech, and is cited by the judge based on these 24th and 33rd articles of the 1981 law, the judge needs to examine if these elements are reunited. So it needs to see the context of the words and the intention of the author. And it is only when the author of these words seizes the European Court of Human Rights, that this European Court of Human Rights will decide if they estimate that the words are serious enough that the request is inadmissible. So it is done by a court decision, a prescription. For example, there was a case between Le Pen and France. Jean-Marie Le Pen, who was a member of far right in France, was condemned to a 10,000 euros fine for inciting people to hatred. And his request was accepted because even if it is admissible that a political member can provoke, his speech cannot go above and beyond a limit, which is the respect of other people's rights. Considering his speech, the European Court decided that the request was obviously inadmissible. So the national judge will look if the elements that constitute the infraction, if these elements are reunited, then the Article 17 is taken before the European Court as a motive to declare that this person cannot rely on the benefit of the convention before the court. Thank you very much. We had another question about the Tutsi community in Congo, but I do not see elements, factual elements, so I think it would be difficult to base, to reply. I don't know if Natalie wants to reply. It is someone who is mentioning threats to discrimination towards the Tutsi community in Congo. I know that in the paper there are a few decisions by the African court, the South African court. So without deciding on this, because we do not have elements, do you want to say a few words about an African approach to the treatment of hate speech, handling with hate speech?
Right. So we have limited case law before the African Court of Human and People's Rights. What we do have as well, though, that can be looked at is the United Nations framework, which is dealt extensively as well in the reports. If somebody would like to look at, and particularly the limitation grounds of Article 19, but also Article 20, Part 2, which prohibits advocacy to inter alia discrimination. So that could be useful. Is that okay, Francois? Because we, as you said, we don't have facts. Can I ask a question? Francois,
Of course.
did you say that in the translation that you had, the French report, there was no reference to handicide or to Perinchek, or did I understand wrongly?
Yes, exactly. In the French version, I heard one decision, but I did not hear the name or the year. That's why I mentioned it in my comment for the participants.
All right, okay. But in the actual report, you've seen it there, right? I just wanted to, okay, perfect. Okay, thank you.
I wanted to write something. So the paper of Dr. Alkiviadou mentions a very important decision, Tulane against the Human Rights Commission in Southern Africa. It is quite important. So the South African Constitution has provisions that are very protective of freedom of speech, because it demands that the law demonstrates a real incitement to cause damage or prejudice. It is quite rare, and it is not in the French Constitution, for example. There is another question that could be interesting, and I think this question is for Bernard Chevalier. Someone is asking if the French jurisdiction apply or have applied the 6 criteria of Rabat Plan on prohibition to incitement to hatred. So the social and political context, the status of the actor and the object, the content of the speech, the scope of the disclosure, and the probability of the prejudice and its imminence. I don't know if you can hear me, but I do not remember that such convention was quoted, but the criteria that you're mentioning are similar to what the law asks us to examine and take into consideration. So actually, what appears through our exchanges is that, generally speaking, there is a community of opinions in all the jurisdictions of the different states, European states, obviously, because we're submitted to European states and the control of European courts of human rights, but more broadly, in the perception of what can be called hate speech and sanction that it deserves, these criteria can seem quite divided. But I do not recall a French decision on this. I don't think we have targeted this convention in France. Very well, thank you. Mr. Chevalier, I just wanted to comment. I haven't seen it either, but I'm not, I don't have your knowledge on the French jurisdiction. I just wanted to observe something. The 6 criterion in the Rabat Convention about imminence, it is a criterion that is less present in the French judges' rationale than in other jurisdictions. We are thinking about the United States. And the paper of Dr. Alciviadu mentions the importance of this, how the United States put at their core the question of imminence in a very protective approach to freedom of speech, freedom of expression. I do not see any other questions. So as I wait for other people to send a question, I have a question to Ms. Alciviadu. She mentioned Area Perinchek against Switzerland in 2013 and 2015. And to sum up, it is that they refused to extend the application of Article 17 to the denial of Armenian genocide. And I was wondering if this refusal to extend the scope of Article 17, can we not see this as a will by the court to limit to the benefit of freedom of expression? Sorry, there was a cough in between. I could not hear one keyword.
All right, so if the refusal, if I've understood the question correctly, if the refusal of the court in the Swiss case is a kind of bonus in the free speech battle, is that your question? Okay.
More or less, yeah,
More or less,
schematic
okay.
way.
So I think there are 2 parts to this. It's a very, I think your question exactly sums up what the situation is, and it's complicated in terms of how to respond to it. On the one hand, that definitely creates this kind of inequality of genocides, let's say. So if we take away, if we look at a genocide from a completely personal perspective, the Armenian genocide for Armenians is the Armenian genocide, right? So if I'm not treating that genocide as the court of the Council of Europe region in the same way that I'm treating another genocide, then definitely I'm setting up a hierarchy in terms of what matters and what doesn't, because in this case, there was the refusal. That would be the one answer, but that's not complete, because the second answer would be that if we used Article 17 for what it was supposed to be doing from the very, very beginning in the travaux préparatoires, and how it was examined and developed post-war Europe, which was a kind of very, very strict mechanism for the very serious cases where democracy itself was at risk, right? And then we had a proper analysis of speech cases. No one's saying that the court would have to accept Holocaust denial. It's simply removing the Article 10 examination, right? So since the court over the years, even during the time of the commission, has had this approach to the Holocaust, and then we get that one Armenian genocide case where we do have a thematically parallel situation, because we are talking about the level of genocide, then I think that either we should see the same pattern being followed for genocide denial more generally, or, and it would be better that not would have happened with another genocide, but as we've seen, for example, there was some discussion in the French case, Garaudy versus France. There was a discussion that actually now Article 10 analysis is important. A slow move from the court to actually examine the speech aspects of cases. Because don't forget that we even have a case whereby Article 17 was used in a private letter which denied the Holocaust. But when it came to the public denial of the Armenian genocide, we had no imposition of Article 17. So I think I wouldn't call it, let's say, in my own words, a victory per se, but rather this imbalance, but not because I think that Article 17 should just be used for anything. I mean, there are historical facts that any person with a reasonable mind cannot doubt, right? But at the same time, there are the legal tools to allow at least for the legal treatment of speech. So in a very quick way, it would be it's unfortunate that they didn't follow their general approach to genocide denial because of the ramifications of the actual victims of the genocide. At the same time, I think avoiding Article 17 more generally would be beneficial for the examination of Article 10 before the European Court of Human Rights.
Thank you very much. I think it's a very complex question. We have a few minutes. Someone is asking if the national jurisdiction in France take into account the opinion of European Community of Human Rights. They do not have the same authority as the European Court. And I am talking, but Bernard Chevalier can add an element if he wants, if I was wrong. I think we have reached the end of the webinar. I wanted to thank everyone for their participation, the speakers, the participants for their very technical questions. I'm sorry we didn't have more time to answer the questions. I think we saw that there isn't only one way to respond to the hate speech, and a technique to fix the thresholds, the tolerance threshold for hate speech. I wanted to thank Colombia, Freedom of Expression, and the French version that will help us to follow the future cases of hate speech. I'm giving you the floor back, Anderson. Thank you for this perfect moderation. Thank you, Nathalie Alkeviadou, Bernard Chevalier, for your precious intervention. To the participants, thank you for your presence. Do not forget that this video will be published on the channel of the CGFoE. And I invite you to participate in the next webinar on the 2nd of April on the African case. I also ask you to send your contributions or comments that are always welcome on our website. Thank you and have a good day. Goodbye.
Thank you. Bye-bye.